All right, let's be real. We've all heard the horror stories about HOAs. But what happens when things go from just plain annoying to, well, illegal? Today, we're diving into a real-life David versus Goliath story from Arizona. It's one homeowner up against the powerful association that was supposed to be working for him.
And it all boils down to this one super frustrating question. What can you actually do when the very group meant to run your community just ghosts you? We're going to follow one homeowner's incredible journey to find that answer, and trust me, it says a lot about your own rights too. So our story here kicks off with something incredibly simple. Just a homeowner trying to understand the rules of the community he lived in. Picture this. It's late 2013, and a homeowner named Rex E. Duffett gets a notice from his HOA, Suntech Patio Homes. It says his fees are going up. Now, like any of us would, he just wanted to understand why. Totally reasonable, right? And his requests were nothing crazy. First, he asked for the meeting minutes where they decided on the fee increase. Makes sense. When he got nothing, he followed up a few months later asking for the most basic stuff, the rules and regulations and the architectural guidelines. You know, the kind of documents every single homeowner should be able to get their hands on no problem. So, what should have been a quick, simple exchange of documents? Yeah, it didn't go that way. It quickly turned into months of pure frustration. This is where he started getting the classic runaround. I mean, just look at this timeline. He asks for the meeting minutes in November, and then crickets. Radio silence for months. It wasn't until April, after he had to threaten legal action, that the HOA's management company finally gets back to him. And their excuse? Oh, that meeting never happened. And even then, he had to wait until June just to get some of the documents he'd asked for way back in March. And this is where the two stories just completely diverge. When Mr. Duffett filed an official complaint, the HOA's response was simple, clean. All complaint items have been resolved. But his sworn statement? The complete opposite. I disagree. I have never received the documents that I requested. You've got two totally different versions of reality here.
So, after hitting a total brick wall with emails and phone calls, Mr. Duffett was left with basically no choice. He had to escalate things and take this fight to a formal hearing.
He went the official route. He filed a petition with the state agency in Arizona that actually handles these kinds of disputes. This wasn't just another angry email. This was him invoking his rights under the law and basically forcing the HOA to answer for their actions in a formal setting. Now, the whole case really hinged on this one simple but incredibly powerful piece of Arizona state law. We can just call it the 10-day rule, and the law is crystal clear. An HOA has 10 business days to provide a member with records they've requested. That's not a suggestion, it's a legal requirement.
And so, the stage was set. A date was on the calendar. July 24th, 2014. On that day, both Mr. Duffett and the Suntech HOA were ordered to show up before an administrative law judge and finally settle this thing.
After all those months of waiting, of filing paperwork, it all came down to this moment, the hearing and the judge's final call. But on the day of the hearing, something pretty wild happened. Or, well, something didn't happen. Suntech Patio Homes, the same group that insisted everything was resolved, they just didn't show up. A total no-show. So with only Mr. Duffett there to testify, the judge looked at all the evidence, and the conclusion was absolutely clear, no ambiguity at all. And this is a direct quote from that decision. This tribunal concludes that Suntech violated the charge provision of A.R.S. Chapter 33, 1805. Bottom line, they broke the law. And that violation? It came with a price tag, $550. Now, this wasn't some fine paid to the state. Nope. This was a direct reimbursement to Mr. Duffett for the fee he had to shell out just to file the case and get it heard. The victory was just complete. The ruling didn't just get Mr. Duffett his money back, it officially named him the prevailing party. And maybe most importantly, it ordered the Suntech HOA to actually follow the law from now on when it came to document requests. Okay, so one homeowner won a case against his HOA. You might be thinking, why does this one dispute from years ago still matter today? Well, it matters because it reveals something much, much bigger about the power balance in these communities. See, this story isn't just about one guy getting his paperwork. His fight reinforces a fundamental principle for the millions of us living in planned communities. Homeowners associations are not some private club that gets to make up its own rules as it goes. They are legal entities, and they are bound by state law. They absolutely have a duty to be transparent with their members. So what can we all learn from this? First, know your rights.
Find out what the actual laws are in your state about HOA records. Second, document everything. Mr. Duffett's emails were his proof. Third, if you're getting nowhere informally, don't be afraid to use the formal channels that are there to protect you. And finally, as this case clearly shows, sometimes persistence really does pay off. And all of that brings us to the final question, one for you to think about. After hearing this whole story play out, it's probably worth asking yourself, how well do you really know your own HOA's rules? And maybe more importantly, how well do you know your rights?